All right. Well, thank you everybody for coming out to the presentation tonight. We're actually really excited about this. First, my name is Philip Jordan, run the energy practice here at Gray Reed. The idea for this particular presentation came about like a lot of good things at a bar in downtown Houston during NAPE. At the beginning of the night, Billy saw me at the end of that night, and he would probably think, man, how could anything productive come out of that particular night? But it did. So met Chris down there, and he runs the PLM program at the University of Wyoming, among other things. We started talking about like oil and gas plays in the northern DJ Basin. I was like, man, are you just a landman? Like, what do you do? He's like, no, I'm also an engineer, went to the Colorado School of Mines. And I was like, oh, that's cool. Then he starts talking about this carbon capture well that they've done and the presentation that he's making. And so we were like, hey, we should bring him down here to talk about it. So that's how this came about. That's also a little bit of background about Chris. Like I said, he's a director of the PLM program and a lecturer at the University of Wyoming, also a petroleum engineer from Colorado School of Mines. University of Wyoming and Chris, they recently obtained approval for the first CO2 storage well in the state of Wyoming. He's a prolific author, lecturer. I think you'll enjoy listening to him. Our other speaker is Josh Smeltzer, who's a tax lawyer here at Gray Reed. His practice is focused on tax disputes. He was with the Department of Justice, and he's got a tremendous background in the tax advantages and carbon credits that come with these types of projects. And so I think everybody will enjoy hearing the presentation tonight. So they can kick it off.
All right. Well, thank you. So they told me I have to stay at the podium because we're recording this for people that can't be here today. So this will be quite a challenge for me. As Philip says, I teach at the University of Wyoming, and I don't stand still very good. I kind of walk all over the place. So I'll do my best. I didn't bring any notes, so I might need to look at my slides. So bear with me. One minor correction. I am an engineer, not a petroleum engineer. I have a general engineering degree from the Colorado School of Mines. They don't even offer that anymore, but a little bit of petroleum engineering. First, I'd say, thank you to Philip and Gray Reed for inviting me to come speak. The hospitality has been fantastic. You all have a great place here. I can't imagine a much better view. So I'll kind of get into it. A lot of you are probably like, why are we talking about carbon capture? And some of you are like, oh yeah, I've been getting calls this week from clients that want to know about this. And actually, I'll tell you, we're fortunate enough. We actually have someone in the audience from Dallas that Alicia. And their company is actually working on an injection project in Wyoming as we speak. So I might pick on her a little bit. But in any event, my background in this space came about 4 or 5 years ago. The oil and gas professor at the University of Wyoming, who is actually the reason why I teach at the University of Wyoming, I had hired her as an expert back when I was doing some oil and gas litigation. She says, hey, what do you think about teaching? I said, well, I haven't taught anything, but it happened. So she asked and says, well, now that you're here, Chris, I got this grant to do some legal research in carbon capture and storage, Class 6 permitting. You want to join on the project? So I wasn't going to say no. She's my friend, and I just kind of said, this is great and all, but this seems really theoretical. I mean, why are we spending all this time researching these things that it just didn't seem economic to me? And she was way ahead of the curve, understanding that there was movement in the industry that we would see some of these projects come to fruition. So really, my involvement comes from someone that's much smarter than me that let me tag along. And we've researched various issues and wrote a few papers over the years. Mostly in Wyoming, some of our focus is on some of these federal lands issues that fortunately in Texas you don't really have to face, but we can't really do a project in Wyoming that's not going to somehow include some federal land. So that's a lot of my background here. As this indicates, I do teach the landman program at the University of Wyoming. It's great and fantastically fun working with our land students. So any of you that know land students or students looking for a potential university, I do think we got a pretty good program and always need more students. And I can say, starting next fall, we actually just got approval for a 3+3 program where students will now be able to get a law degree in 6 years through our program. So we're really happy about that. And then I also keep busy practicing law, mostly oil and gas, and more recently, some of these carbon sequestration issues. But I'll go to the first slide, and it's kind of just an introduction. And I know we have various understandings here of what carbon capture and storage looks like. Alicia probably has seen this picture before. I stole it from the Wyoming Department of Environmental Quality. I think it's really helpful in kind of understanding what is carbon capture. And from a traditional sense, one, we're just taking carbon and putting it into the ground. One of the questions is, well, where does that carbon come from? And that's some of the distinction, or what we're going to use that carbon for. And just because I'm standing at the podium, usually I'd go over here and point out. But if you look at this picture, what you can see here is it's showing, in a traditional view of what carbon capture is going to look like, I might capture the carbon, have a pipeline to an injection well, and I could inject it into the ground for just storage purposes. And that's what we call sequestration. If I'm not using that carbon for anything other than to put it in the ground, we call that sequestration. We'll talk a little bit here in a bit. That's going to be permitting under what's called a Class 6 well. In Texas, you all figured out a long, long time ago that, well, we don't need to just put carbon in the ground. In fact, you were putting carbon in the ground to pressurize the formation, to produce oil and gas, enhanced oil recovery. So that's another use of carbon injection, and that's what we call typically CO2 EOR, or enhanced oil recovery. You might also, in Wyoming at least, there's formations that you're going to go produce helium from, and you produce a lot of carbon dioxide, and you might inject that carbon into the ground for storage. And so you do have maybe some disposal related to oil and gas development. But in a traditional sense, we're talking about sequestration and enhanced oil recovery. And Josh is going to talk really quickly a little bit on the differences from a tax standpoint on if based on a project, whether you're storing it or whether you're using it to enhance oil recovery, how that looks from a tax standpoint. But I would actually say, in Wyoming at least, when we originally thought of carbon capture, this is what I would say the industry was focused on. But more recently, we're seeing a lot of interest in this area of the combination of carbon capture and underground storage and hydrogen development. And you ask, why is Wyoming kind of out front of this and doing all this work? One, we're an energy exporting state. Our state only exists because we export energy. We happen to have a lot of fossil fuel resources, especially coal, oil, and natural gas. And if we stop using those resources, or if consumers outside the state of Wyoming stop using those resources, our state's in a lot of trouble. So that's actually where I work, the School of Energy Resources. Our goal is to promote energy development in Wyoming. And if our consumers say, well, we don't like these energy resources that produce carbon, we're not going to buy them from you, that's problematic for the state of Wyoming. They'll probably start charging me an income tax to live there. And so people a long time ago said, no, let's, regardless of whatever we think, let's meet the demands of our consumers. And they're asking more and more for carbon-free energy sources. Well, so all these technical folks said, well, you can produce natural gas, which is CH4, and you can process that or reform that natural gas, and you can be left with components of CO2 and H2, and hydrogen itself is an energy source. So Wyoming has now taken this really progressive approach to basically try to say, hey, let's look at hydrogen potential as an energy source. You can actually convert hydrogen to ammonia, which is NH4, and then it's easier to transport through boats into international markets and stuff. So a lot of these projects that various developers are thinking about are saying, okay, well, if I take the natural gas that's produced wherever and I go process that gas, I'm left with CO2 and hydrogen. Well, I can inject that CO2 in the ground, and as Josh is going to tell us, I can actually get a tax benefit for doing that. That's called the 45Q tax credit. And then I can sell my hydrogen, and that's my energy source. And so for Wyoming, hydrogen development combined with carbon capture and underground storage seems to be a way to really improve Wyoming's economic outlook. So I'd say Wyoming's kind of all in on promoting hydrogen projects. And I can tell you, we are seeing in the state of Wyoming a lot of interest of carbon capture and underground storage combined with hydrogen generation. So we call that blue hydrogen. So if you hear the word blue hydrogen, some of you might have heard it before, usually you're talking about converting a fossil fuel energy source into hydrogen and carbon dioxide. The other one you might hear about is green hydrogen. That would be taking a renewable energy source such as wind or solar. Through electrolysis, you can break down water. We know water is H2O. That gives me oxygen and hydrogen. So you say, well, why would you do that? From a renewable standpoint, one of the concerns is, well, the sun's not always shining when you need the power. The wind's not always blowing when you need the power. It's meeting peak demand. If I create a gas, now I have something that's more easily stored, kind of like a battery, and I can meet the grid needs a little bit better. So that's when you hear green hydrogen. Now, green hydrogen might work great in certain places, but it requires a lot of water. And for anyone that's been to Wyoming or the Desert West, that's something we don't have a lot of. So there are challenges with green hydrogen, but I can tell you at School of Energy Resources, we're actually investigating, well, what if we combine green hydrogen with produced water from oil and gas development? Rather than injecting that produced water into the ground, can we use it for hydrogen generation? So those are some of the projects that we're working on. But that's just kind of an overview. And I know this is very forward-looking because there isn't a lot of projects right now where people are breaking down CH4 to produce hydrogen to inject the CO2 and ship off the hydrogen to wherever. This is a potential that we might see for the grid. The state of Wyoming has a pretty strong belief that hydrogen has a good fuel potential. One thing I like is hydrogen can be converted to ammonia. I can put ammonia on a ship and I can send it to international markets. I think that the future in this space is great. And for you all, you might say, well, this is great. What does all of this require? Whether I inject carbon into the ground, whether I'm producing hydrogen, well, that's gas. I need pipeline infrastructure. So all of this development would require quite a bit of pipeline infrastructure, which is great for developers and a lot of the work we do. So that's just kind of an introduction on what is this stuff and why would we do it. So before I hand it over to Josh, I just ask if there are any kind of questions on the basics, and some of you probably already know some of this. I do have a question.
So I've heard of gray hydrogen and pink hydrogen. Are those kind of variations?
Yes. So pink hydrogen is something that would be taking a nuclear fuel source and then basically electrolysis of water to create hydrogen. You don't have a carbon dioxide component from that. So pink hydrogen would be similar to green hydrogen, just not a renewable energy source. That would be with nuclear energy. And I can actually tell you, I'm working on a project this summer looking at, can we classify nuclear energy sources as a renewable energy source? That's kind of another topic for another day. But so that's when you hear the word pink hydrogen. When you hear the word gray hydrogen, and gray just has like a bad connotation, I guess. And I look outside, oh, it's gray today. That's usually talking, it's very similar to blue hydrogen, but generally you're not injecting the CO2 into the ground, so you generally have CO2 emissions. So it's using a fossil fuel source to create hydrogen, but generally you're not doing anything with the carbon other than emitting it. So yeah, great question. Oh, got lots of questions.
Where and have they been doing that? Is that how ammonia is carbon released into the.
Yeah, I think a lot of traditional, historically, traditionally, and I haven't been involved in the ammonia industry and hydrogen industry, to be honest. I do know there's a big hydrogen plant somewhere near Houston. It's like one of the biggest hydrogen plants, I think, in the world, maybe. And I do believe it's based on a fossil fuel fuel source.
So they're just releasing the carbon dioxide.
I believe so. I honestly don't have a lot of background in gray hydrogen. Alicia might know more than me.
They do. They're actually releasing it into the atmosphere.
Yeah.
And then I think there's one in Wyoming, Simplot, where they
Oh, yes.
do the same thing and release it.
That's right. Yeah. And then
They're bad people.
they're bad people. Yeah, I think they're trying to run a business, and luckily, now we have an economic. We have an economic reason to put the carbon into the ground, which Josh is going to talk about. Like, otherwise, you wouldn't inject it into the ground if you didn't make any money from it.
I mean, I've heard recently that Talos Energy, I don't know if you're aware of that project along the Gulf Coast,
Mm-hmm.
that, I mean, they're spending something like $3 billion to direct air capture
Yeah.
around some of these industrial sites, and then put it in a pipeline and basically put it down in the Gulf of Mexico.
Yeah, I am not overly familiar with the project other than I just spoke at a Great Plains event in Louisville a month ago, and they had some folks that talked a little bit about that project. It sounds like their plans are pretty phenomenal. They do have some issues depending on how far off coast you go, whether you need some federal land rights to do that. But unfortunately, I don't really do a lot of offshore because in Wyoming, we're about as far from the ocean as you get.
Well, and Oxy Petroleum is building like the largest direct air capture facility in the world. I think we're going to put it in.
Yeah, and I think the direct air capture, if they can make it more economic. I don't know. Alicia probably knows better than me, but I would think capturing it from a emitter might be a little bit easier than direct air capture, but I don't know the economics involved there. And I think I had one more question before I turn over to Josh. Then I'll be back to talk about the regulatory. Yep.
What percentage of the CO2 would you say is used for, whatever storage versus what's used to push out the oil to,
Oh,
a lot of
so you're talking about for enhanced oil recovery?
Yes.
Well, I think that's going to be project independent. And one thing, understand, I'm a lawyer now. I have an engineering background, but my technical background is pretty limited. I think generally, when you do these projects, you're hoping to push as much oil, create as much pressure as you can, and to keep as much CO2 in the ground to keep the reservoir pressurized. So that's your goal. But in these EOR projects, because you don't have just injection wells, you have production wells. So in those production wells, you're actually going to have some CO2 released. And in fact, when you're talking the tax credit for EOR, you have to account for that. And Josh might talk a little bit about that. You have to basically, when you're seeking the 45Q tax credit for EOR, you do have to account for how much CO2 you put into the ground, but also how much CO2 comes out through your production wells. They can model that through their modeling and monitoring. I think it's probably project dependent on exactly the percentage there. So I honestly can't give you a good number.
How recyclable that CO2 is, if it's just mainly for storage, or
Yeah.
it actually has uses, a lot of uses. That's how that way.
Yeah, and when you say CO2 uses, it's actually interesting. There's people looking at the ideas of injecting CO2 into certain types of rock to actually create some sort of mineral that maybe you have an alternative use to the CO2. Mostly what we're talking about today, though, is what I'll talk about later is mostly just putting it into the ground for under what we call a Class 6 sequestration permit. And the reason you'd say, well, that's stupid, you're not creating any commodity, and I agree with that. I mean, you're just putting it in the ground, you're not creating something to sell, right? But what incentivizes that is the tax credit. And you get a higher tax credit for sequestration than you do for enhanced oil recovery. So with that, that's actually a perfect introduction. I'm going to turn over to Josh Smeltzer. I'll let him tell you, but he's a tax attorney here at Gray Reed. And just in our practice yesterday, I learned more yesterday than I knew about any of this stuff. So I already learned a lot. And so I'm going to turn over to Josh, and he'll talk about some of these incentives of why you would just inject CO2 into the ground.
Sure. All right.
First off, thank you. Because, I am a tax attorney and that's what I've done for 18 years in my career. I don't usually when I speak, it's to other tax people. And so I kind of feel like I've been invited to sit at the cool kids table for a minute here. And so I appreciate that as well. So let's make sure I hit the right button here. So the tax code essentially is the largest piece of social welfare legislation that we have in the country. Almost every time we want companies or individual taxpayers to behave a specific way, we institute a tax provision for it. We make it worth their time. And that's essentially what this is. But incentive tax benefits, we have all kinds of different types, and this one just happens to be for oil and gas. And for renewable energy credits and all these other things that we've been doing to try and deal with greenhouse gas problems and other things along those, we've had a lot of these come up lately. There's a couple of things that you need to know about incentive tax credits if you're trying to take advantage of them from a tax perspective, just so that you can be aware of them. The first is legally, the burden is always on the taxpayer. There's a Fifth Circuit case, and it models several other circuits throughout the entire country, that the burden to prove entitlement to a tax credit is on the taxpayer. It's all on you. So if you don't dot all your I's and cross all your T's according to the regulations and the code provisions, then you just don't get it. And it's your burden to show that you're entitled to it. And that's important to think of, because as you're looking through here, if these tax incentives are a huge part of your business model, you need to be very careful with the things that you do. A little later in the presentation, I'll talk about this, because a lot of these deals are done through partnerships. And while I will go over, because I was told not to take too much time, I'm not the star here. So I will, most of the stuff I'll go over is in summary fashion. And I'll try and point out the things that you should definitely think about when you're looking at these deals and the things you want to consider and look at. But the tax code provisions and the regulation provisions, I mean, we could do an entire presentation just on those. But, right, a lot of it is just math. And then there's a couple of things that are really legal principles that you should be aware of and are completely outside of the regulations. You wouldn't even be looking in the regulations for the general limitations on partnerships and the general tax limitations we put on transactions in general. And you wouldn't even know those were there, but they could undo your entire tax credit and not make it viable to you anymore. Oh, I'm not supposed to walk. That's going to be hard for me too. I pace like a tiger. It's intended to promote investment, and a lot of this, it's been around for a while, but the Biden administration made a commitment that they want to be net zero by 2050. And the only way that's going to happen is through several renewable things, and the only reason that people will invest more money into that is if they get a tax benefit for doing so. As I said, you're not producing a commodity, especially in sequestration. All you're doing is putting something in the ground because the government doesn't want it in the air. And in exchange for doing that, there's a cost associated with that, and they're going to offset that with a credit. Now, the important thing about a credit as opposed to a deduction is it's dollar for dollar tax savings. And that's important. So, right, like if you have a tax credit, every dollar that you get in credit, it reduces your tax liability by that same dollar. A deduction, right, just reduces your overall income, and then your taxes are applied to that otherwise. So credit is very, very valuable. And it's very valuable to investors, right? Because that's a lot of these things, a lot of these projects, and we've seen these in other renewable energy spaces, in the solar industry, in the wind industry, all these other ones as well. They want to get investors to come in. Well, you may have a developer or somebody who can do this project and is not that interested in a dollar for dollar tax savings, but a wealthy investor might be willing to invest in a project more readily if they can get that tax benefit. And the way that you set that up is important, because if you go too far, you could end up undoing the entire benefit that way as well. There's a lot of cooks in this kitchen, and Chris will talk more about this when he gets into the regulatory. Tax is only a small piece of this. You've got the EPA, you've got the Bureau of Land Management, you've got the Department of the Interior, you've got a ton of people that have to sign off. There's tons of red tape going on before you can get here. So you want to make sure that you have all of that stuff before you go. So permitted uses and reporting. So for sequestration, you inject it into the ground. And there's several things that the regulations allow you to do. It can just be in an underground formation. It can be in an abandoned mine. It could be in a well that's no longer being used there. And the regulations allow for other things for you to inject it into, as long as it doesn't leak back. So it mentioned, right, you may have other wells where it's leaking out of there. In order to qualify for this, you have to meet what he called a Class 6 permit, which also has a whole bunch of reporting and monitoring requirements. Those are important because, one, the calculation for the credit is based on how much you're able to capture and how much you're able to store and make sure it goes nowhere. But if you're wrong with your model and it leaks more than you expected, you have to recapture some of the tax benefit that you got there. And so it's important to know that you may need to recapture that. So when you're doing your models, you might want to build in a buffer if you need to, because you might end up having some of that come back to you. Enhanced oil recovery. So the way that it works is you get a certain dollar amount, and there's a dollar amount in the code, but it's pointless to kind of quote that. It's $10 and $20, but it is adjusted for inflation, so it's no longer that. But essentially, enhanced oil recovery, because there's a benefit entitled to it, it's about half the credit that you would get for just storing it in the ground. And the incentive for that is just because you get no benefit from putting it in the ground commercially, but you get another benefit for the other. So they don't need to necessarily encourage it as much. So I have this chart in here, and I don't know if the materials will be provided, but if not, we'll make sure that you get it. Now, the one caveat with this chart is I took it from the Congressional Research Service when they first came out summarizing, because I feel like this is a really good way to get a lot of the tax information at once about things that you want to consider but it comes with the caveat that, as I said, the numbers are no longer right because it adjusts for inflation. I believe they've adjusted for inflation before this is there. But this gives you the amount. The key thing from a tax perspective is the dates and the amounts. Those are the main things. As you can see at the top, February of 2018, if your project started before then there's different amounts and different metrics that you have to meet. One specific limitation is that it's only limited to I think it's 75 million in there that it says on there. Much of that has been used, but not all of it. But after, you have a little bit more flexibility because they're trying to do things along those lines. You also have to hit certain minimums. You have to capture. They're not interested in very, very small captures. It has to be at least 500,000 under there before you even start to get a credit for it, before you even qualify to go on there. The two terms that are kind of legal terms that you need to think about is when something is placed in service, because that's what it used up there, and there's a definition for that, and it's nuanced and a little complicated, and also beginning of construction. So if what you're doing is building something that is going to do this capture, like a gigantic from the air, direct air capture, or you're sticking something on there to capture the carbon and do that kind of stuff, your construction has to begin. And there's two separate tests that meet that, and a safe harbor. Safe harbor is what most people go with because you can be guaranteed the results that's there. Now, this, I think, is one of the most important things to consider about. So at the Department of Justice, I did partnership litigation like crazy at that. And that's where a lot of abuses from a tax perspective occur, because there's a lot of flexibility in partnerships to do a lot of crazy things. And people do all kinds of crazy things with partnerships. That's important, even if you're not doing crazy things, because they're looked at very closely. And they have a lot of extensive rules that have to be complied with. So one of the structures that was very popular with renewables was this flip structure that they would use. And as I understand it, some of the carbon sequestration projects are using it as well. To summarize it, essentially what you do is you have these investors come in, they invest a lot of capital, and you allocate to them 99% of the value of these tax credits. And then they get that tax credit to return the investment that they put into the project. And when a certain benchmark is hit, it flips. And then the developer gets the majority of the tax credits, and it does that. The reason that this structure is so popular and has been used over and over and over again is what's the first structure that was used for wind, and it was approved as a safe harbor by the IRS. And I got the Rev Proc up there where it says that it was approved. So they started using it for solar, gangbusters. And then IRS counsel put out a memo and said, just so you know, it only applies to wind. There is no safe harbor for solar. There's no safe harbor for carbon. Now, presumably we can say that if they were okay with it for wind, at least the partnership structure, the way that it is, and the rules for passive investment and other things like that, those are probably okay. But the IRS, it's also important to note that the IRS is reserving its right to look closer and tell you that you got it wrong that way. Also, there is a general prohibition that you cannot sell tax benefits. You just can't. Tons of people have tried. And if the only reason for the transaction, it has no regulatory, it has no business purpose, it has no other reason. The only reason that anybody would do what you're doing is to obtain tax benefits, you're going to have problems with that. Now, normally what you do to prove that there's something other than that is that you have a real stake in this transaction, right? You're not just somebody turning money over. You know, I have $1 million in income. I'm going to give $1 million to you. You're going to give me $1 million in tax credit, and I don't have to pay anything. This is fantastic. I don't want to know what you're doing. I don't want to sign any agreements. I don't want to have anything to do with anything, right? That gets you in trouble. So real stake in the transaction. And this came up again in another type of wind thing, and the IRS produced, and I've got there too, the Rev Proc there, some things that cause problems. And they're things that you can totally see would happen in a normal business negotiation. Indemnification clauses. If I can't claim this credit, you're going to give me the money that the IRS didn't give me, right? You can see that happening in there, going there. All kinds of other protections that were there. Or they would build into, listen, invest in this. You have no downside potential because I'm going to cover you, right, for this kind of stuff. A real participant in a business venture has both the upside and the downside. And if those are missing, you could possibly have the problem. What the problem is that it will be deemed to not be a real business venture. And at that point, what you end up in is the service and the courts have a bunch of tools that they can use to remove steps from your transaction, collapse steps from your transaction, just deny the entire transaction whatsoever, take out loan agreements, take out other things to reflect what they call the economic substance of the transaction. That's where you get down to the last bullet point, the last thing you'll hear from the tax guy. But the economic substance doctrine, it was a judicially created doctrine for the longest period of time. And then it was finally codified in the Internal Revenue Code. And it essentially says that if the economic benefits If the economic substance of the transaction is not reflected, and the only reason that anything is being done is for the tax benefits, then the courts have the authority to recharacterize the transaction so that it fits with its economic substance. Now, the Joint Committee on Taxation, which is the group of really smart tax people, way smarter than me, who advises Congress on tax policy, has put in a footnote there that when it passed this law, that the economic substance doctrine should not supplant congressional purpose for legislation. That should not stand in the way. If Congress proposes to give a specific tax benefit, you shouldn't undo it with the economic substance doctrine. Now, I cited a case down there, and although it says carbon, it's not a carbon case. What these people were dealing with were alternative fuel mixtures, similar type of thing. It was a fuel mixture. You got a tax credit for it. Someone designed a great plan, they thought, where they could mix these fuel mixtures, deliver it, charge a huge fee for the delivery of the case. And what ended up happening was the fees far outweighed any money that they made. But with the tax credit, they were able to offset a ton of income for their investors. And Bob's your uncle, everybody's happy. They said, no way, in the court. And what they argued was they cited this provision and said, hey, listen, Congress intended for this benefit to happen for alternative fuel. We have an alternative fuel. The fact that our structure, wasn't profitable, you're just punishing us for not being profitable, and that's not fair. And the Court of Federal Claims said, doesn't matter what the Joint Committee on Taxation said. One, it's not law. Two, it doesn't stop us from looking at this thing. And three, the economics don't make sense, and that's not going to happen. And so it undoes it. It's important for this to be known because you should know that if you draw too close to a line where you're using these carbon credits for something that doesn't have a whole lot of business purpose to it, you could be in trouble. The second thing is on the front end, often when you're doing projects and business, right, everybody's focused on the economics and the business deals and the rights of the parties and everything along those. Nobody ever thinks about taxes. Redheaded stepchild of the business transaction. But nobody ever thinks about taxes. So you don't document, a lot of these business purposes or other things that you might not otherwise do. And the only reason you would document them is in order to protect yourself against an analysis. If you get questioned later and you have no piece of paper to point to, corporate minutes or something in the agreement that's documenting what the business purposes and other things were, well, now you have to either testify to it to an IRS auditor, the most skeptical people in the world, and say, well, that's what we meant at the time. I know it sounds kind of self-serving now, but that's really what we meant at the time. It's better just to have that documented as you go through. And right, it could be a regulatory purpose. It could be a marketing purpose, right? Businesses, especially nowadays, can benefit financially from being a carbon conscious business and that kind of stuff. You don't put that in any of your documents, you can say it, but if you put that at the beginning of the project or as part of the terms, then they see that was something that was included in there. You just want to be a little bit more detailed and document as you go through so you don't end up with problems further down the line. That's all I got, unless people have questions.
So I know varies from state to state, but those pollution control tax exemptions as well.
Yes.
How do those play with federal?
So the fact that, and that's a good question because, right, like you can double up on a tax credit as long as both apply, right? A tax credit is very much a check the box thing. So as long as you meet all the requirements, you get it. And that's true of a state credit as well. And it doesn't, as far as I know, it doesn't offset. Like the state doesn't say that it doesn't. Because the other thing that you can think of here, all of this is new technology. There's also a research and development credit that you're entitled to. And right, if you have a research and development credit for what you're doing and you have the carbon sequestration credit, you can take both credits. The only thing there is, and a state credit on top of that. There is a lot of tax incentives that are going to this because the states are interested, the feds are interested, and they're interested in new technology, they're interested in that. You can combine those all together. One caution is just that nobody loves paper more than the IRS does. And you just want to make sure that you have enough paper showing exactly where lines are drawn. Most tax disputes, as I'm sure with a lot of other disputes, are just not being able to draw those clear lines between where something stops and starts. So you want to be able to make sure that you have all the expenses clearly marked in each thing. That's where, accountants and other people who keep track of that kind of stuff are interested. Yeah.
I'll just add to that even if you do have all the documentation lined up, the IRS still wants to just say it's not enough. And
Yep.
we don't necessarily buy what you're selling. So you have to check the box and make sure you document everything that Josh said. But sometimes it's just mud wrestling for dollars.
Well, and that is really kind of important to think about as well, because if you have a lot of money in line, right, and you think you might have some issues there, you just have to prepare for a fight. And there's two things that I'll think about that. I don't often get involved until somebody has already gotten a bad decision from accountants usually handle most of the audits and that kind of stuff. And then when things go south because the IRS does something crazy or doesn't accept somebody's paperwork, even though it's reasonable, that's usually when I get the call because they got an unexpected result at that point. And you just prepare. But sometimes I have been involved on the front end because I know there's a lot of money involved. It's an important issue. It's something like this that is new and the regulations aren't necessarily as clear. I do a lot of crypto work. Nobody knows what's going on there. And so you have to build your battle plan kind of frontward. There's two good things about doing that. If you consult an attorney earlier, the law is very clear that that still is protected by attorney-client privileges work product because in anticipation of litigation includes administrative disputes if you're anticipating for an administrative dispute. So you can do that.
Inquiry this week from a state auditor wants all of my client notes from our interviews with engineers. And they're talking about potentially subpoenaing that, but we didn't have that in client attorney privilege.
Yeah. It's very, very important because, right, like, when you're doing these projects, you want to be able to put it's very important from a business perspective as well to be able to put all the options on the table. The only problem is you don't want the IRS to know all the options you considered, right? Because everybody has different risk tolerances, as I found. I tend to be pretty conservative, but some of my clients they have a higher risk tolerance than I do. And there's nothing wrong with that so long as you're still coloring within the lines. But right, like you don't want all the information that there was a less risky thing to do and you chose to take the riskier vent on there. And there's no reason that they should be entitled to that, that you have to do that, right? You just get an attorney involved. If you need excessive accounting stuff, you set up a Covell agreement so that accountant comes under it. There's lots of things that you can do. I'm primarily a litigator, so right, like I'm used to battle plans and setting up fortresses to protect it. Yes, right? Like same type of thing. These partnership agreements are very, very important because when the IRS busts something up for economic substances, this is exactly where they go. They go to those provisions. They look for what's both there and what's not there. When they do that. And it's just the way that it is. So to protect yourself, careful drafting, absolutely key. And consider the tax guys, right? We're sitting in the corner and we'd love to come over. All right, I'll turn it back over to Chris.
Well, Josh said that the tax part is boring, but we wouldn't be talking about this if it wasn't for the tax. So to me, it's actually the most critical piece of the puzzle here. I did quickly address. I had a question. One of the questions on layering tax credits. What is fueling a lot of projects is not just the 45Q tax credit, but if you look at the state of California, they have a low carbon fuel tax credit, and a lot of developers are looking at how could I potentially claim both the 45Q and California's tax credit, and really have a good amount of financial money there. And so I have done some research on California's low carbon fuel tax credit. It is a big standard, but it's out there and available. The other thing that Josh made me feel really good about when we were talking yesterday, so I've kind of been all over the place in my practice, from title to transactional to regulatory to litigation. And when I draft agreements, I always have tons of recitals, and everyone's like, "Chris, why do you put all this crap in your document?" And I just like, well, it helps me keep organized, and I don't know, maybe I need it. And Josh said, he said, well, now I can actually prove. Look, when we were talking about this partnership agreement, here's the reason we were doing it. It says it there in those recitals, and maybe that's a little bit better defense. So he did make me feel better about my practice, so I appreciated that. And I will say, in these projects, as Alicia can tell you, is especially when you're talking about projects where you're going to an emitter and you're capturing their emission and then you're injecting it, you're going to have partners in these projects. So you're going to have some very sophisticated agreements. And if you're dealing with multiple emitters, you're going to have multiple agreements with multiple parties, and it gets really complex really fast. My background is not in business planning, so I don't have a lot to say there. But I guess the reason that I'm more for here, my background in this is really from the land and regulatory side. Is okay, how do we actually permit one of these projects? And what's been really fun for me is there isn't a lot of these projects countrywide. There's not precedent for this. And so all the work I've done in the last couple of years in some of the companies I've been helping is really just trying to figure out, okay, we have these statutes, we have these regulations. Now, how does it work? And in terms of BLM, we didn't have any statutes or regulations or guidance, but as of 3 weeks ago, now we at least have something. So it is, this area is quickly developing. There's a lot of capital sitting there on the sidelines saying, how do I get in? And the boondoggle, as Alicia can probably tell you, is the regulatory side. It is unfortunately very complex and very technically demanding. And so for those that do transactional and regulatory work and land work, this is where they all mix, and you have to work together, because now we've got to actually say, well, I'm going to go out and lease someone. Well, if you don't know how the regulations work and what your lease needs to say, your lease might not be all that helpful. And so really, before you begin a project, you got to have kind of an understanding of how the regulatory process is going to look. I can tell you this Class 6 permitting process is going to be difficult. I wish I could say it's not, but the unfortunate thing is it probably is. And so a lot of you might have clients coming and saying, hey, I'm going to go do this project. They picked up some leases somewhere and they want to get running tomorrow, but unfortunately, you probably need to slow them down and really make sense on the regulatory, how you're going to check all those regulatory boxes. So you've heard me a lot today talk about Class 6 wells, Class 2 wells. In this space, we use those terms a lot, but most attorneys, even in the oil and gas world, aren't using the words Class 6 and Class 2. We just say disposal well. And so you say, well, what is that? And really it comes down to any injection well for the disposal of any substance underground. Back in the 1970s, I actually have the date wrote here. Let's see if I can read it. 1974. That's when the Safe Drinking Water Act came out. And the purpose was, this is during the time of environmental regulation, and the government says, look, people are drilling wells and putting stuff into the ground. Well, we drink water that, is connected with the surface, and we don't want the water contaminated. So basically they said, okay, EPA, we're charging you with regulating all sorts of anything. Anytime you inject a fluid into the ground, you've got responsibility to regulate that. To do what? To protect drinking water sources. So all of our regulation here, when you hear the word Class 6 or Class 2, it really comes to the Safe Drinking Water Act to protect potential drinking water sources or freshwater sources. That's really what we're doing. And there's 6 classes of wells. And in carbon injection, we're really talking about 2 different classes. You'll hear the word Class 2 or Class 6. And the regulatory structure for a Class 2 is much less burdensome than the regulatory structure for a Class 6. So you say, well, I want a Class 2 well. What is a Class 2 well? A Class 2 well could be the injection of carbon, but it has to be related to oil and gas development. So currently, the state of Texas has primacy to regulate Class 2 wells. If I want to go inject carbon waste, or if I want to go get an EOR, I go to the Texas Railroad Commission and I apply, and it's really a Class 2 well. And that is the injection of carbon related to the production of oil and gas. So generally, we're talking enhanced oil recovery, but we actually do have Class 2 projects in Wyoming that aren't necessarily related to enhanced recovery. I could drill a gas well to a deep formation and maybe I produce carbon dioxide. Maybe I'm going to inject that CO2 as a waste product. Then I have perhaps a Class 2 well, even though I'm just storing carbon. That falls under Class 2 well related to oil and gas development and is not under what we call Class 6. Now, Class 6, from a regulatory standpoint, has a lot more, from a technical standpoint, a little bit more onerous provisions. So what is a Class 6 well? Well, a Class 6 well is just injecting carbon, not to produce oil and gas, not related to oil and gas development, but just to store it. So I can get that 45Q tax credit. So when you hear the word Class 6 well, that's what we're talking about. And when the Safe Drinking Water Act came out, basically the classes were created. EPA said, okay, states, if you want to regulate any of these classes of wells, you can apply to EPA to obtain what's called primacy. That's where the state takes over the regulation. And the requirement for obtaining primacy is that the state regulations must meet or exceed EPA regulations. So if you did that, you applied to EPA, you said, here's our program, you could get primacy. And you'd say, well, why would a state want to do that? And in fact, I would say this is probably currently the number one driver of where carbon sequestration projects are being located. And really, it comes down to a timing standpoint. It's believed that a Class 6 permitted EPA probably is going to take longer than a state that can actually issue the Class 6 permit, because if it's within the state, they've got people on the ground, they got a little bit, better local understanding. And in Wyoming, we're really incentivized to get these projects moving. So Alicia works with Department of Environmental Quality in the state of Wyoming because they're the agency that has jurisdiction. Wyoming is currently one of 2 states that has primacy to issue Class 6 permits. The other is North Dakota. So a lot of developers are saying, hey, I like Wyoming, I like North Dakota, they have primacy. So if you want to do a project in Wyoming, your Class 6 permit is filed at the Department of Environmental Quality, which is the agency that acquired primacy. Now you're all like, well, I'm Texas, folks. Why do I care about Wyoming? Yeah, I agree. I mean, if you're going to do projects in Texas, that may not matter as much. But I do give you some good news. Has anyone been following? Texas is applying for primacy. The Texas Railroad Commission, I believe just a month ago, announced it was opening public comment for its regulations to submit to EPA to regulate Class 6 wells. So I believe the Class 6 wells will be regulated by the Texas Railroad Commission if approved, with, I believe, the assistance of, they call it Texas Environmental Quality. Does anyone know it? Texas something? TCEQ. So I believe they have 2 agencies involved. In Wyoming, we also have 2 agencies involved. It's actually our Department of Environmental Quality that actually issues the permit. My understanding from Texas's application would be the Railroad Commission that issues the permit. But I'd say this is a really exciting time for Texas because submitting for primacy, if you get primacy, a lot of developers are going to say, okay, well, I can timely get a project through. I can, have some sort of regulatory certainty. I can get lending financing because I have some of that regulatory certainty. And I think people look more favorably towards Texas. So my understanding is that application is being made in October. So I could actually have some pointers to kind of say that some of our stumbling blocks, I think, or not stumbling blocks, but difficulties from a regulatory process and some of the requirements of Class 6 permitting that I can tell you now. And maybe Texas can address some of the problems that I see that are slowing projects down in Wyoming. Yeah, so as my slide indicates, obviously primacy is a huge driver in where companies are looking to site projects. I believe Louisiana, does anyone know? Louisiana, I believe, just submitted their primacy application, so they're another state. And then Texas, and I'm not sure of any other states. I have met with some folks in Colorado, and the state of Colorado is hopeful, but I think they're a little bit behind the wheel here. And so I don't know when the state of Colorado will be submitting an application. But ultimately, it's probably beneficial if a state wants development to obtain primacy. Otherwise, if I want to cite a Class 6 well in Texas today, I got to go through EPA to get that approved. And by the way, for those that do federal work, anytime that a federal agency approves any project, you might be triggering what we call the National Environmental Policy Act, or NEPA, which is a lot of work in determining environmental impact. So for those in Texas, you don't worry about NEPA as much as we do in Wyoming, where every project involves NEPA almost, because our state is a lot of federal lands and a lot of federal minerals, federal split estate minerals, and so we are constantly dealing with the federal government and federal agencies. All right, so that's just a broad overview of who has the jurisdiction to actually issue the permit to drill the well. I mean, that's your first concern, and so I just have a couple points that I want to talk about that I think are really important to understand very early in the project, and that's, what does a Class 6 application require? What do you actually have to monitor and control as part of a Class 6 application for a carbon injection well? And why that matters is, if I'm going to go out and lease someone's pore space, I'm going to have to know, what rights do I have to pool or unitize with someone else's land? How much pore space do I actually need to lease? And that actually is the critical point here when we're talking about Class 6 permitting. I think it was Ethan yesterday told me, is there some sort of like inverse rule of capture in carbon sequestration that I just can go lease a little small parcel? If I inject and that carbon goes over on someone else's ground, well, I just captured their pore space. I think that was the point. He didn't quite say that. Well, one, I think you're going to run into some potential trespass issues. I think there's case law out there that's pretty definitively said, well, if you inject something or release something on your ground and it's going to go to the neighbor's ground, well, that's probably a trespass. It's not like where you're putting a well on your own ground and then fluids are just naturally migrating. It's a little bit different. You're actually knowingly putting a substance that might go on someone else's ground. So one, you probably have a potential trespass concern. But outside of that, from a regulatory standpoint, it's more important to understand, when I issue a Class 6 application, so I go to, in Wyoming, Department of Environmental Quality, in Texas, eventually the Railroad Commission, what do I have to show them as far as, what do I have leased? What land rights do I have? What control do I have over the area to actually show that I can inject carbon into the ground and I can monitor where I need to monitor? I can perform, you're going to hear this word, corrective action over this area. What is that area? And to me, more importantly than common law trespass issues, it's this area that you actually have to be able to control to get approval for a Class 6 application that's really going to dictate the land side of your project. And unfortunately, I can tell you, in my opinion, it's more onerous than it should be. But I think there's some opportunity here to maybe get some clarification from EPA on what it ought to be. I'm just going to speak here. I think I have Wyoming is an example, and I know I'm supposed to stand in front of this, but I might have to go over there and at least read because I don't have it memorized. But first, if I inject carbon into the ground, okay, there's two things you need to think about. One, I inject into the ground, I'm creating pressure, that carbon's going to expand. So I'm going to have this, based on the geology, I'm going to have this plume of carbon underneath the ground where the carbon is. So we call this the carbon plume. But also, if I inject carbon into the ground and I inject it into a sandstone that probably had some brine, well, that's going to force the fluids they're going to be displaced by the carbon. You're going to increase the pressure. So it's going to push fluids, it's going to pressurize the fluids, not just where the carbon is, but for a bigger area. And this is what we call the pressure plume. And so in carbon sequestration, we're worried about two things. We're worried about where's the carbon go and how far does this pressure extend. And EPA rules, and we're going to talk about them here shortly, have kind of said that you've got to have effective control over on what they identify as the pressure plume. And we'll talk about what is the pressure plume. And so now from a land perspective, not only am I worried about where the carbon's going to go, I actually kind of have to worry about, okay, where's the increased pressure? Because that falls into these definitions. So really quickly, I know I'm stepping away, hopefully it picks it up, but Wyoming's current regulations, which were approved by EPA when Wyoming obtained primacy, say the area of review, and this is, so in Class 6 applications, the area of review is the area that's reviewed as part of an application. You have to have technical evidence over the area of review. It is the three-dimensional extent of the CO2 plume, so we talk where the CO2 goes. The associated pressure front, so not just the CO2, but also that wider area of the pressure front of displaced fluids, as well as all overlying formations. So I drill to 12,000 feet. My area of review is not just 12,000 feet, it's 12,000 feet to the surface. That's within my area of review, part of my technical requirements in the submission of my Class 6 permit, and the surface area above that region. From Wyoming DEQ, Alicia is probably tired of this regulation, Chapter 24, Section 13, when submitting a permit for a Class 6 well, an operator must demonstrate they will have access for all required present and future corrective action within the area of review, and the operator will take such action to prevent the movement of fluid into or between USDW's drinking water sources, including use of materials with the carbon dioxide stream. So what does that mean? Well, that means anywhere if you're area of review, if there's some sort of connection between your CO2 injection and a drinking water source, you have to show that you are able to monitor and control and perform any corrective action over that connection. Well, you say, well, I'm going to put carbon into 8,000 feet in the ground. I mean, carbon's not going to migrate up 5,000 feet. Well, what if someone within your area of review had drilled an oil and gas well to 12,000 feet? Now you have a wellbore that penetrates your formation that does connect to higher formations that are drinking water sources, potentially. And so in your Class 6 application, you actually have to show and say, okay, we've identified all these potential areas that may connect to a drinking water source, and I show that we have effective control over those, that we can rectify any problem there. And so you're like, I see people's heads spinning. What does that incorporate? Well, pore space, we're talking surface, right? When we're talking oil and gas wells, who are we talking? We're talking the mineral estate. So in development of Class 6 wells, there is such an importance on not just who owns the surface, but who owns the minerals. Because if I want to go get a Class 6 application, I've got to show that, one, I've got the necessary approvals from the mineral owners to do this, that they're not going to come in and inject into my formation and increase the pressure where now I don't have effective control. And And I also have to show, one, that the mineral owner is not going to actually drill into my formation to produce oil and gas. So one, your formation probably can't be a formation that is conducive to oil and gas development. But in Texas, I'm guessing they drilled a lot of wells really deep, maybe a long time ago. And maybe those wells have long since been plugged. Well, now if I'm going to go get a Class 6 application area under these regulations, and Texas is going to have an opportunity here, you're going to have to figure out, how am I going to get access to that well? How am I going to be able to show effective control? How am I going to be able to show that a competing developer is not going to come in and inject and cause a problem where now our pressures are too high, that's going to be too high for the formation or something like that? So what that all leads to is, when you want a Class 6 application, you actually have to basically show that you have exclusivity to that formation in that area. Because if you don't show that, it's really hard under this regulation to meet the requirements for a Class 6 well. And you're like, wow, when I did a Class 2 injection well, I didn't think of any of this. And that's true, because we don't have those requirements for a Class 2 injection well. So when we're talking, I got a question.
Well, I was just, like, how do you document that? Do you have a lot of geological, geophysical
Yep.
evidence that you're doing seismic runs on all that? Because
It's all modeled, yeah.
you're modeling it, because you can't really do it until you
Do it, yeah. And so that's a great question. And the Class 6 requirements, one, your application's based on seismic. So you really can't do this project without shooting seismic. So that's one of the first things you have to do. Maybe you acquired seismic from an oil and gas developer a long time ago. You didn't maybe shoot it yourself. So one, you need the seismic so you can actually model it. But also, as part of your Class 6 application, they require ongoing monitoring until site closure and actually beyond that. And so you actually have to have monitoring wells that is monitoring the pressure throughout your area of review to make sure that, hey, we don't have a problem, that the CO2 is not migrating, we're not endangering freshwater sources. So when you do these projects, you're definitely using, it's not just, oh, here's my injection well. You got to plan out your monitoring wells. You got to figure out where those go. The first thing is, identify, are there any wells that are currently producing or were drilled in the past that penetrate your formation? And so you've got a lot of things on your plate. Ideally, you would go to a formation that's deeper than any oil and gas production, and then maybe you wouldn't have to worry about, mineral development and wells penetrating your formation. But that just doesn't always exist. You're driven by geology, and your best place to inject CO2 might be in a formation that there was oil and gas, wells drilled through. And now you got to figure out how you're going to make that work.
change the economics too.
Absolutely.
10,000 feet versus 5,000.
Absolutely. Yeah. And Alicia's probably, so I keep calling on her because she lives here in Dallas, and her company is actually pushing forward a Class 6 application here in Wyoming for a project in Wyoming to inject in Wyoming. And they're in an area that I believe has lots of potential formations, but also lots of formations that have historical hydrocarbon potential. And so they've probably been racking their brains with the technical folks on these issues.
Yeah, that's the gospel.
And it's crazy because we don't have these requirements for Class 2, and whether it's a Class 6 or Class 2, we're injecting carbon in the ground. We're not doing anything different. It's just a much higher standard, and the casing you need for a Class 6 well is a much higher technical standard than the casing you would need to inject CO2 for enhanced oil recovery. And it's just the nature of the regulations. For whatever reason, EPA's guidelines went quite a bit further than they did for Class 2 wells. I don't know the historical reason. I just say, from my engineering brain, I'm like, man, we regulate this so hardcore. It's more than, substances that I would say are much worse than carbon dioxide. But I point this out. So these are the Wyoming rules. And by the way, how much time do I have? Does anyone know? I'm very poor at keeping my time. No one knows. All right, I'll talk until you tell me you're tired of hearing me. I won't make it too long because it gets into the weeds pretty quick. But I am working on a project in another portion of Wyoming, not this where I drew this map. And we're really concerned with this area of review because from a land perspective, if I have to go get the rights for the carbon plume, maybe I can get all those people. If I have to go to the pressure plume, I'm dealing with a lot more landowners. And the more different parties I put into a project, I mean, I would love to say, oh, I do a project and every landowner agrees and we have no issues. I mean, is that your experience? And by the way, I actually represent a lot of landowners, so I have a very unique practice. I'm all over the place. I just take whatever. And people are like, oh, you're with us, you're against us, where are you? And I'm like, no, just trying to help facilitate the transaction. But you'll have landowners that'll just say no to say no, and so it can create headaches. And so I drew this map, which brings up a couple other issues. Here, this is a picture of the Green River Basin in Wyoming. You can see it overlaps into portions of Colorado and Utah. One point of that is basins don't respect state lines. You could have geologic basins that overlap multiple states. And I have these two circles here. One, well, here's my yellow circle of where the carbon actually goes, and here's my green circle of where the pressure goes. You say, wow, that green circle is a lot bigger. The actual stuff that I've seen from some of the technical folks I'm working on, that yellow circle is a lot smaller, and that green circle is actually a lot bigger. And when we're dealing with these plumes, and they're typically radial, well, what's the radius of how do I calculate the area of a circle? It's pi r squared. So the further I go out, I'm exponentially increasing the area I'm dealing with, the landowners I'm dealing with. How am I going to allocate the proceeds from a project? It gets quite a bit bigger. And so these are issues that I wish I would say that have been completely resolved. And you're saying, well, hey, look, your map, your circles are going on different states. And why did I do that? Because actually I spoke at a conference in Louisville with the Great Plains Institute. They said, hey, we heard you were dealing with this transboundary issue. I'm like, yeah. They're like, well, can you come speak and tell us how to resolve it? I said, I can come speak, but I can't tell you how to resolve it. So when you actually deal with this area review and this pressure front, the lands you're dealing with are so great. In fact, one of the projects I'm working on, it involves 3 states. And you say, well, how does that work? That's a great question, because in Wyoming, we have primacy. I go to the state of Wyoming for my Class 6 permit, but if I have to go show a control there in Colorado, well, I have to go to EPA because EPA has jurisdiction. And you say, well, can EPA why can't they just do the whole project? Well, I think that comes down to their regulations. 40 CFR 145.1E says, upon approval of a state program, the administrator, as we as lawyers, the word shall, that's the cases out there say shall, says there's no ways around the word shall. So it says shall suspend the issuance of federal permits for those activities subject to the approved state program. So it is my opinion that once a state does obtain primacy, the EPA cannot then issue a permit in that state unless that state were to subsequently lose primacy. So it's my opinion, and no one's challenged this, so I can't say it's true or not. It's just what I think, is for this kind of project, you're going to have to go get approvals in both the state of Wyoming and the EPA, obviously, unfortunately, slowing down a project. One other point I'd say is, okay, well, if Colorado, hurries up and follows Texas's wise lead and gets primacy, can we work together? And I would say, yeah. Then I have a potential solution. States can work together. States can enter into what's called compacts. And in the West, we've already done this. We don't have a lot of water. We've entered into agreements to say how we're going to split up the water when we're dry. That's a state compact. I do believe should various states get primacy, I think states could then say, okay, let's not have to go to 4 different states for a project. Let's allow one state to kind of take the lead. I do think that potential is out there. So so when they said, what's a remedy? I said, well, states get primacy and then go enter into agreement just like any private parties would do. So that's this big issue of carbon plume versus pressure plume. I do have on the slides EPA's guidelines, and one of the thoughts is it's kind of my view that Wyoming, regulations when they submitted for privacy went a little bit further than EPA. So my recommendation to Texas is, to the extent you can, when you submit your proposed regulations for Class 6 primacy, try to whittle down that area of review to the extent you can. That's going to help project development. Exceeding EPA's requirements that I think Wyoming might have done unintentionally is not helpful. So that is my recommendation to the state of Texas. But we can see from EPA's guidelines, what is the area of review? It recommends, use the word recommends from their guidance, that it encompasses the maximum extent of the separate phase plume or pressure front over the lifetime of the project in the entire time frame of the model simulations. You say, well, what is pressure front? Because, those engineers say, well, I could take it out 1,000 miles and it might have a 0.00001 impact. I think EPA rules kind of address that issue. They say, what the pressure front really is does it create a pressure that's enough to move a fluid? If so, it's within your pressure front. So I do think EPA's guideline 40 CFR 146.84D probably indicates that the pressure front means it's a pressure differential that could actually move a fluid. So I think that is the EPA's interpretation. I don't know. I think Wyoming might have gone a little bit further than that. Alicia is dealing with Lilly and DEQ, and I'm sure you guys are having those discussions. I know we're running short on time, but another big regulatory concept that I heard of, and I don't know Texas law. I'm licensed to practice in Wyoming and Colorado. I had the fortunate opportunity to teach oil and gas law at the University of Wyoming Law School this past year. I did learn some Texas oil and gas law. I tried to understand your accommodation doctrine idea, but when you come from a forced pooling state, it just didn't click. So here you're going to hear me actually advocate that Texas adopts some sort of forced pooling for Class 6 wells. And it's not that I'm trying to dictate how Texas needs to deal with its property rights. It's just I have a hard time seeing how Class 6 wells are going to happen if there's not some sort of compulsory unitization. And that comes back down to the point of, okay, I just told you this area review is going to extend miles. Well, you're going to be dealing with lots of landowners. So let's say you go get agreements of 99% of the landowners in the area review, but that 1%, that one fella, he says, yeah, I like your company and all, but I don't want anything on my land regardless. And I think you are probably going to struggle with your Class 6 application if someone right in the middle of your plume there says, hey, I have this old well on my land. You can't get there. You don't have an agreement with me. How does the project go forward? That's a big issue. So without this idea of compulsory unitization, I think it's going to be tough in Texas. In Wyoming, we have compulsory unitization. And what I mean by that is, let's say I'm a developer. I go out and I've leased 80% of the land, the surface area within the unit. This one person owns 19% of the unit, and they just say no because, they're nice enough fella, but they don't want anything on their land. Well, it's a bummer for the other 81% owners because now it can't happen. Well, Wyoming statute says as long as you get 80% of the people to agree, you can go to the Oil and Gas Commission and seek a unitization order where we combine those tracts of land, force the people in. And by the way, so when we talk about unitization, it can be voluntary. All the people can say, we're going to combine our tracts. We all agree. That's the best scenario where you don't actually need a compulsory unitization. I just think realistically, especially when you're dealing with surface owners that might be really broken up, you might get a holdout that's going to make project development happen. So why you would need compulsory unitization? Well, if I just say to that one landowner, well, if you don't want to be a part of the project, sorry, it's going forward, and I know the carbon's going to go into your ground, that's probably a common law trespass. I got a question back here.
I think it's different when you're not paying a royalty.
Yes.
Royalty is the key word.
Yeah. And
You don't pay somebody royalty for this thing? No. So why should I sign?
yeah, so you do get, so one, you're asking on the leasing standpoint, am I just using your ground and I don't get anything? If I'm a landowner, I'm going to say no. If you're going to say, I'm going to come to your ground, and this is why, well, you're not using it anyways. Well, if I own a parking lot in downtown Dallas and I just say, hey, I own this parking lot and I'm not using it so anyone can park freely, would I do that from a business standpoint? No, because I could charge someone to come put their car there. And so the exact point here is if I own pore space as a surface owner, I might not need it myself because I'm a farmer, I'm not using it. But if it's something that someone else wants, it has value and I want something for it, right? And so every pore space agreement that I've seen compensates landowners in some way. You can structure those in different ways. It can be an annual payment. It can be based on the amount of carbon injected. Most agreements that I've seen have been a combination of some sort of annual per acre rental payment plus an injection fee, cents per, per metric ton of CO2 injected. That's the common I've seen. So I would say if you're going to go out and, try to develop these projects as a developer, you better be reasonable in your agreement that you're actually offering the landowner something, because otherwise, of course, they'll say no, because I would say no. So yeah, one is the royalty. But that actually is a great question because in unitization, well, now I'm combining area, and how are those different royalties in different agreements, how's that going to be allocated? And if I'm forced into this unit, do I get to participate in the unit and share in the cost of developing the unit, or do I just get a royalty? These are issues that we're actually facing in Wyoming. I can't get into too much specific because it's kind of attorney-client privilege. I am working with some other people on redrafting some of our unitization. My personal belief is if I'm forced into these units, as much as I hate to take away this freedom of contract and say, well, you get this royalty based on other agreements in the area, that's probably the only feasible way. In oil and gas, we say, well, you can participate in the oil well. And that makes sense because I know how much the oil well costs, and then I know how much I sell the oil for, so I can participate and come out with numbers. In this world, let's say I'm a midstream company that had an existing pipeline that used to be a natural gas pipeline. It was in the ground, and I said, I'm getting rid of natural gas. I'm going to turn it to a carbon pipeline. Based on this CO2 pipeline I already have in the ground, I'm going to go to all these emitters and enter into these complex partnership agreements for these tax sharing credit agreements. How then would one of those owners participate in the project? It would be, for me, I'd be like, my mind's blown. So my personal view is in unitization, it probably needs to be some sort of monetary payment that's provided. I don't think there necessarily should be a right of participation. I think those are great things for people to debate. I think the Oklahoma forced pooling model seems to make a lot of sense in the unitization world. Just from the projects I'm involved in. I'd love to hear from Alicia's projects. She probably can't tell too much. If she has any holdout landowners and what those discussions on unitization looks like. Unfortunately or fortunately, in Wyoming, we have not had a single unitization application yet. This is still theoretical, but it's coming. And I'm just saying for the state of Texas, if you really want to get in front of this, Texas probably, and to my knowledge, and I could be wrong, I don't believe Texas has any unitization statutes for carbon sequestration. I do believe to really incentivize development, it might be a necessity. I'm hoping there's something I'm missing that maybe it's not. And it's not driven by property rights as much as it's driven by Class 6 regulations, that if you don't have this right, how are you going to meet the Class 6 regulation? So it's not really a property requirement as much as a Class 6 requirement. We could solve all this if EPA would change their mind and make their guidance and their rules much less onerous, and then we wouldn't be having these discussions. So I think were we ending at 6:30, or what time are we ending? Does anyone know? No one told me.
Nobody told me either.
So those were the main points. I have a whole bunch of other points that I would get to, but I just, you don't need to hear me talk all day. I just kind of wanted to talk about some of these issues that really you got to think of up front in a project development from a leasing standpoint. Your company wants to get involved in. It's the Class 6 regulations are going to drive the agreements that you need. And that's just because this area of review and what area you need to control and how are you going to bring in the different landowners into a unitization. In Wyoming, DEQ's kind of put out a statement that says, well, you actually need a unitization in order to get your Class 6 permit. I'm not sure I agree with that because you could get voluntary agreement. But from a practical standpoint, you're probably going to have to go get a unitization order. And more importantly, if you're a developer, in Wyoming, if I go out and get the unitization order, now I am the only developer that can be in that area. And so I've captured exclusivity. What do I have? I have regulatory certainty that's going to help finance the project. If I don't have unitization and anyone, and it's basically whoever drills first captures the flag, boy, that's going to create I mean, frankly, I kind of like that free market, but that could create quite a race to put holes in the ground. And how's that going to work with Class 6 regulations? So, I just say in Wyoming, we worry a lot about federal lands. BLM just issued guidance. We've been working on that, trying to get them to do that. And now they finally, up until 3 weeks ago, BLM didn't. So in Wyoming, most of our lands, BLM surface, federal lands, there was actually no process to go to the federal government and get a permit to sequester carbon. There was no process. So as of 3 weeks ago, we now have guidance to do that. So we can presumably go apply for a permit. It's under what we call Title V of FLTMA, the Federal Land Policy Management Act. It's actually what we call the right-of-way provision of FLTMA. So there's actually now theoretically a process to go apply. There has been a couple applications. None have been approved. I'm very interested to see how this all shakes out. But luckily, we seem to be such a political country. It seems like both sides of the aisle want to reduce carbon. The oil and gas industry, they certainly do, because they say, well, our consumers want less carbon if you give me the ability to put it in the ground and we can still sell our oil and gas. Other people say, well, we need carbon in the ground. So a lot of this stuff, I will say, has been a joint effort of the various political parties. So the last thing is, because Tara Rigetti, who's obviously on all the articles I've ever wrote in this space, here's some of our publications out there. The Carbon Storage Future of Public Lands was a law review article, and we were basically trying to tell the BLM, here's what we think you should do, and luckily the guidance kind of mirrored what we said, so it worked out. But with that, I'll leave it open to, I guess we have time for a few questions for either me or Josh. Josh might have more important questions. No questions. I always tell my students, okay, you understand it all, great. Well, thank you so much for.
I will say, I forgot to say, but if you are seeking some sort of CLE, CBE, or landman credit, the forms are out there. Make sure you fill them out before you go.
Yeah, I'm gonna steal one. We get extra because we're speaking.
Yes.
And I'm way behind on those. All right. Well, thank you all so much. I'll be sticking around for I guess a little bit if anyone has any questions. Thank you for inviting me out to Texas. I know this isn't on the top of everyone's list, but I do think it is a area that's really has the potential to really take off. At least in Wyoming, I work for School of Energy Resources, and they told us that basically do everything you can to help facilitate this development. So that's the marching orders that we have. So, well, thank you.